Today's session is mainly about adjustment of status, and this is probably the one where most people feel comfortable with because regardless of which kind of immigration firm you're in and you're operating, you probably have done adjustment of status. And in the past decade or several decades, adjustment of status has been roughly pretty straightforward, right? You prepare the 45 application, you prepare the 765 I-131 application, the applicants qualify, you fill it out, you file, you have an interview, you don't have to interview, the case gets approved, and it's done. But in this administration, right now, we're seeing it completely reverse. And I think it is a time to really concentrate, to think through this adjustment of status application process to see exactly how you want to specialize. And there's so many different ways. There are appearance attorneys that they don't do the entire paperwork and they just go with the client to the interviews. That becomes more and more important now. There's the preparation application part, which is pretty important because there's more and more things that they want and more red flags that can cause a case to be denied. And then there's the whole strategy part, which becomes also increasingly more complex. What's easy to overlook in this stage are your dependents. Are your children able to get a green card with you? A lot of people get a green card not for themselves, but for their entire family. But what if their kids are already too old? So doing a good CSPA, Child Status Protection Act analysis right at the get-go, right? Before you even apply for I-130 or I-140, does your children qualify for CSPA? So that's a CSPA issue is under the 485 or NVC framework. But if you don't know about that and you just immediately let client embark on one of these journeys, maybe that's too late, right? So for example, if you marry to a US citizen, maybe your child could get a CSPA immediately because you can file for adjustment immediately. But if you're doing the I-140, maybe that will take too long. So you chose the wrong path. Also, following to join. You can get the green card first, but when are they gonna get the green card? That's a separate issue. What about if you have unauthorized work in the United States? If you've had unauthorized work in the United States, how long has that been? Because under the 245K, you can waive 180 days of unauthorized stay, unauthorized work. That's pretty important in deciding which path you want to immigrate. If you have an I-130, I-140, a labor cert application filed before April 30th, 2001, and of course, it has to be filed and it could be approvable on its face, then it can waive a bunch of things afterwards. Any sort of unlawful presence, any sort of unauthorized work. Whereas at 245K, it's only 180 days of unauthorized work, unauthorized employment. But this is important. This one comes up over and over again. Somebody who's on H-1B but falls out of status and then now can adjust. Well, they can qualify for 245K, right? 180 days covers only 6 months. And there's a lot of timing issues regarding that, right? Like it could only cover unauthorized from the last lawful entry. So you have, if you entered and then you have a bunch of unauthorized stay afterwards, sorry, 245K doesn't cover it. Thinking through adjustment of status, National Visa Center. Now, some people, they have to do adjustment of status because they know in their home country, if they apply, it's almost 100% guaranteed they will be denied. Maybe it's party affiliation problems where they know the consulates, the embassies are just so strict that based on their circumstance and what their agents and everybody telling them, they will be denied. So they have to find a way to get into the US first and find a way to do adjustment of status, whether it's tourist visa, change of status, whether it's L1, it's H-1B, other types of non-immigrant visa to get into the US. And with the 75-country ban on so many countries, they can't even do the National Visa Center. They're forced to do the adjustment of status. So they have to get a non-immigrant visa to come into the US to apply for adjustment of status. So there's a lot of strategy that's in this field right now in adjustment of status. Thinking through for the client about the following to join. If the children is abroad, or if the petitioner is abroad and the children is here, then how are they gonna get the green card first and then the other person follow to join to enter the country? Stepchildren, you have to prove that the relationship is real, not just the marriage relationship, but also the stepchildren relationship. What if the beneficiary passes away, right? Like, you get married, but then you pass away. Well, what about your kids? Can the kids still be grandfathered in and get through humanitarian, 204L, be able to get a green card? All those are part of the adjustment of status or the NVC kind of analysis. And that's the stuff that every practitioner really needs to think about and know. Since the filming of this seminar, on May 21st, there's a new memo that dropped. And it's essentially saying getting a green card in the United States is an extraordinary privilege. Normal people should be doing it abroad, but if you're doing it here, you have this higher burden of proof. It is not a change in the law. It is just this discretionary measure where the officer can weigh the positive and the negative factors. So essentially, it's the government saying, if they really don't like your case, they don't like it, even if you meet the requirements by law, based on their discretion, they can still deny you and force you to reapply overseas. Here are the negative factors I'm going to read out. Violations of immigration law or conditions of a prior status. That's really important because let's say you were a student, but you were working on the side. That's a violation of your prior status. Number two, fraud or false testimony in dealing with USCIS or any government agency. Conduct inconsistent with the purpose of the non-immigrant or parole status. So let's say you came in as a tourist visa. Within 90 days, you filed for adjustment status. You came in, you were supposed to be a tourist, but why did you immediately get married and adjust status? Well, that seems like you intentionally lied to an immigration officer. That is false representation, so we're going to deny your adjustment of status. Failure to depart when the purpose of an admission or parole was accomplished. So you had your purpose in being a tourist here. We granted you 90 days. We granted you 6 months. You went to Disneyland the first week. But then why did you continue to stay? You told the officer you're only here for 2 weeks, right? But how come you ended up staying and you got married the third week and then you ended up filing for adjustment on the 90-day mark exactly? Applying for adjustment of status in a category where consular processing is available. You clearly could do it back at home. Why did you do it here and do it now? Are you trying to cut the line? Are you trying to do something, right? That's inconsistent. Intent to circumvent ordinary consular processing. So again, preconceived intent and choosing not to do consular processing for a purpose. These are all negative factors that they're looking into. Positive factors, your family ties to the U.S., your good moral character, the national interests. Other positive factors, long-term lawful presence in the community, right? You've been a student, you've been an employee, you've been working, you have tax returns, you have civic involvement, you have evidence of good moral character, you have no criminal history, you have charitable contributions, you have professional accomplishments, you've demonstrated a benefit to the United States with your employer sponsorship, with your specialized skills and your economic contributions. That's why for a lot of EB-5 individuals, if they had to do consular processing, they might have to wait an additional 2, 3, 4 years, and that would discourage a lot of people from doing the B1, B2 to adjustment of status, and they won't invest $1 million. The U.S. needs the money. So everybody else still coming in, still doing the EB-5, but now you have to prepare that explanation in your 45 application. So that's what we're seeing. The adjustment of status application part is now becoming more critical than ever. It is more difficult than ever. The interviews are more a vetting process as opposed to a benefit process. And it's not just preparing applications anymore. It's also interview prep, whether it's at the consulate or at the interview. Especially business immigration now have a lot of these interviews. How do you build a practice? So again, historically, we've seen certain large firms that do such big volume cases. They pump out tons of I-130s, tons of I-140s. They just focus on the application itself. Adjustment of status is an afterthought. And so if you're doing big volume, you don't have time to thoroughly analyze each individual case with their 45 application because it's so complex and so nuanced. CSPA calculation, it changed multiple times in the past few years, with interviews becoming much more important. Building out an appearance arm for your practice becomes really important. It's not just filing the case anymore. Are you going to go with the client to the interview on difficult cases? Because so many times we've gone to an interview and it was so bad that the prudent move was to withdraw the application and refile, as opposed to waiting for the denial and getting an NTA. Because once you get the NTA, then now you move into removal defense. And if your firm doesn't practice removal defense, well, then you're in a tough spot, right? So if you withdraw the case and potentially can refile the same day or next day, that might save everything, especially if you still qualify, right? If you qualify for 245K or you qualify for something else, you might still be able to save the client's application. So adjustment of status is the core, the central point of almost all of immigration. But now we have seen it is becoming more important than ever. But that's where you really earn your keep as an immigration firm. And that's where AI cannot replace you, right? Really figuring out what you like to do, what you want to do, and what you want to do well. That's the key. If you guys have any questions, feel free to reach out. Take care. Bye-bye.